Welcome to Solving Citizen Legal Encounters. All right, today, the follow-up as promised with Sovereign Citizen Ringo, who was in Judge Wheeler's court. He's back in it again. His attorney's still trying to get out of it, but I'm going to let you check everything out for yourself. Now, there are two hearings. The first one that I already did, which says pre-recorded for people that have come through and haven't seen it yet. And then the second hearing will be the one that just happened today. All right, before we go in, I got to welcome four members: Darth, Think It Through, Rod Bullock, and Jill. Welcome to the membership. Check out the community post because there's something there for you to join into. Let's go.
All right, Mr. Goheen Ringo, can you hear the court, sir?
I can. Good morning, Your Honor.
Good morning. Mr. Campbell, go ahead.
Your Honor, I've had an opportunity to speak with Mr. Goheen Ringo this morning. I had an expectation based off of some recent meetings in this case about how today's court hearing was going to proceed. And unfortunately, those expectations are not how we're going to proceed. I don't know how I can ethically proceed today, as I'm having either a breakdown in communication with my client or he's incapable of assisting me. So Mr. Ringo objects to a 1077 being filed. He doesn't believe he needs it. He's told me he's passed 3 1077 evaluations. I'm not able to communicate with him today. It's much different than how I communicated with him on the 11th. So, you know, I expected to be able to proceed. Our communication has been well while he has been in custody, and I've been able to do it in person. It has not been well today. He wants me to make oral records about motions that may not have good faith basis. They may. I can talk to him about that in greater detail, which is what I have done. I've also offered to set the matter for trial today. But I'm concerned about any kind of affirmative action taken on behalf of Mr. Goheen Ringo, because he's also told me at points that he wants me to be fired, or that I've, asked him if he wants me to withdraw and him to proceed in his own capacity. I don't know how to proceed.
There it is. He wants to fire him. He has motions. What else is next?
So,
Why don't we do this for today? Why don't we set this over 1 week? It sounds like you've had good. I'll get to you in just a sec, Cleve. I do see you have your hand raised.
Thanks. Before, Your Honor, before you make the decision, I think that what I have to say may affect what you're about to say. So I'd appreciate, because I did have my hand up a couple minutes ago, just briefly based on what Brandon had just spoken on the record.
Okay, go ahead.
Thank you. So a couple things I disagree with. He said, unfortunately. I don't think it's unfortunate what was communicated today in our breakout room. I did think that he shouldn't have shared some of the details that he's already, it's too late now because he just put it on the public record. But I think it may have violated my attorney-client privilege too. All I was asking my attorney to do was to make a public record today before Your Honor about the fact that my signature is not on any of the previous in the last 2 years waivers of my speedy trial. And I was asking him, I thought it was a pretty competent legal question, if that makes it a legal document without my signature. I didn't know I was getting ready to be pressed into a 1077 peripheral, territory there. I didn't think it had to do with mental deficiencies myself. Thought it was an intelligent question. Maybe I'm wrong. The second part is, I do believe that the state is well aware, and according to rules of professional conduct for her, that she may be in dangerous territory toward prosecutorial misconduct. Taxpayer dollars are the ones that are paying for any of these proceedings to happen. Your Honor knows that well. Rule 8.3 says that if there is insufficient evidence for any of the undisputed facts in a case, prima facie, that the state knowingly, especially a prosecutor, would be in violation of her moral and ethical obligations, Supreme Court rulings, to pursue justice and not just to merely gain a conviction. The trouble with my understanding in this is there's no evidence in a malicious mischief, and I think that's the one of the cases that I'm up against here today. I'd asked my attorney briefly, we didn't have enough time to talk, and we've talked about this before, if it's his professional opinion, if there is a possibility that I would even be found guilty if I did go to trial, he's in a different persuasion than I am, I guess. He thinks that maybe there is sufficient evidence. I don't believe there is. I asked for video evidence. There is none. They can't retrieve it. My own investigator can't. So if the defense can't have any sufficient evidence, that leads me to believe that probably the prosecutor doesn't have the ability to get that video. And if she is able to get the video, then I mean, we get the video too, right? So that, and I don't mean to frustrate Your Honor or Miss Carney or Brandon. I'm not a legal professional. I'm kind of the one in the hot seat here, so all these questions are relevant to me. I'm thinking he's thinking that they're not relevant, but I mean, in the last 2 years, if taxpayers are the ones paying for all this, it's still getting continued out over and over and over again. I've had 2 different attorneys on it.
Okay, he took a shot at the prosecutor, and then he's going to talk about taxpayers' dollars like he really cares about it. I don't think he cares. I think he's just using an argument to try to get out of it.
It seems like it's an arbitrary thing, and that maybe I don't know. Before I go any further, thanks for letting me speak today.
Well, Your Honor, I do have a brief matter to raise to the attention to the court. At this point, the client has asserted what I believe is an unwaivable conflict, in that he has belief that I have waived attorney-client privilege. And so, I mean, we can set it over a week, and in that time, I'll make contact with my carrier in the bar. But I mean, I don't believe I have done that. But I don't know how I can proceed ethically on his behalf in these cases based off of that statement.
Sounds familiar?
So courts at this time, so Mr. Goheen Rango has been coming in front of this court as long as I've been on the bench. So back to 2021. I would say he's not being held on any of our battleground cases. His holds are all Superior Court related. Certainly, there may be compelling legal reasons for a person, if they are pending felony charges, to not proceed on misdemeanor charges first. Ultimately, it's a decision of the defendant and a decision of the attorney. I think what we will do today, because I don't think we're going to resolve this to anyone's satisfaction on a video docket, is I will have Mr. Campbell meet with Mr. Goheen Rango. If it is determined between the two of them that they are not able to proceed together, I don't know if the court has other options available that Mr. Goheen Rango is not conflicted with. But we will cross that bridge when we come to it. Again, at this point, there's no prejudice, there's no hold, and speedy trial is commencing today. So I don't see any kind of immediate reason for rash decisions on the record. That said, if we come to that accord next week and the court has to make some additional decisions, we will get something else figured out at that stage. So, Mr. Goheen Rango, we're going to see you next week, sir, on this matter. That is the 24th, and we'll go from there, okay?
Thank you, Your Honor. I did have a question for you. On the points that I brought up, has Your Honor formed any opinion about any possibility of, you think there may be some prosecutorial misconduct going on, or maybe that taxpayer dollars aren't being correctly appropriated in this? It's been over 2 years. We're talking about, did you say a misdemeanor thing? And I was wondering how relevant of a point it is that none of my signatures are on those documents.
So certainly, Mr. Goheen Rango, those matters can be brought to the court's attention via a motion.
Okay.
I will tell you that a person's oral statements regarding waiving speedy trial and so forth in misdemeanor municipal court can replace a need for a signature. The court has audio records of each time the court has advised you about your right to speedy trial. Generally, I will walk you through that. Again, you and I have had very intelligent conversations in the past about speedy trial. So while I understand maybe from a superior court perspective, why a quote unquote wet signature would have meaning. I don't think that if another judicial officer looked at this with the audio and video records in regards to those waivers, that they would find that you needed to have an actual physical signature on those documents. So I'm just letting you know that I think that would be my perspective on that. Certainly an appellate court at the conclusion of your matters, if you did choose to appeal that matter, certainly in Superior Court in Clark County or the State Court of Appeals could make a different decision, but that would be my educated guess, at least at this time.
Okay, and that's actually what Mr. Campbell told me. So going toward his knowledge of the inner workings and stuff, I didn't doubt him or anything. So that does answer my question on that for sure.
All right, so I'm gonna just get your different cause numbers, Mr. Goheen-Rango, on this set over form for next week. And we'll
Okay.
see you next week and go from there. Okay, sir?
And just because of the nature of this, I do have one filled out, pre-filled if you would prefer it.
You have a return to court?
I do.
Okay, sounds great. Yeah, that was gonna save me some additional writing. Thank you.
For those of you who hadn't seen the first hearing, there it is. Now we're going to go into the second hearing where it gets a little interesting. Let's go.
All right. Good morning, Mr. Goheen-Rango.
Good morning, Mr. Wheeler. Hey,
And Your
morning,
Honor,
Miss Carney.
I'm here on behalf of my client, Mr. Goheen-Rango. I have filed a motion, which I understand Your Honor has reviewed. I still maintain that there is an irreconcilable breakdown in the attorney-client relationship. I do want to provide some information to the court. Spoken with Mr. Goheen-Rango this morning. He believes that our breakdown in communication and our issues as far as it relates to our attorney-client relationship are capable of being repaired. I am being truthful to the court that I disagree with that assessment. However, I want to be fair to Mr. Goheen-Rango and let the court know that. He's asking that we set this matter over to next week for me to go and see him in custody in the jail. I would have seen him this week, but and I don't want to get into there was a miscommunication between he and I. I thought he supported this motion based off of certain factors that I'm not going to get into. He no longer does. I'm welcome. I think I'm back next week, but even if I'm not, I'm welcome to come back next week if it was set over for he and I to talk in person in the jail. I do not believe, I don't have a good faith basis that any discussion that he and I have will change my position as to the breakdown, particularly relating to one issue that I'm not capable of ethically discussing with Your Honor, and a second issue which was discussed in open court relating to my or to the client's belief that I've waived attorney-client privilege. I believe that raises an unwaivable conflict, which I've already been frank with the client about. That being said, he's also asked me potentially about moving forward pro se. I have strongly advised him against that. I don't believe it's a good idea for any client to represent themselves, but he also has a significant experience with litigation. He's been in jury trials, I think, and as well has had lengthy, time to basically research these matters in the law library.
One sentence, he said he shouldn't go pro se. The second sentence sounds like he's reading off his resume for his experience in court.
We are here today. I'm still supporting a motion to withdraw, and I just wanted to provide Mr. Goheen-Rango's perspective to the court.
That's what the resume statement was for.
So I don't know if he wants to speak or not.
So I think my thought is, Mr. Campbell, if you are willing to meet with Mr. Goheen-Rango, sounds like sometime before court next Thursday, I don't think anything will be lost. If indeed after that your position is the same, I think the court would at that point allow your withdrawal. But I want to give every opportunity for this to hopefully work. So I'm going to be setting this matter over 1 week. That takes us out to the 8th of May.
And Your Honor, the only I haven't reviewed the matter for speedy trial issues this morning, so I'm not sure. I think the waiver was to the
Yeah,
14th of
Mr.
April.
Goheen Rango is not being held on any of our
Oh.
cases. He's in a 90-day speedy trial with commencement dates, I want to say on the 24th of April. So we're not very far into speedy trial.
And for some reason, this file, I have other files I think back that may have it, but I believe the commencement date may be the 14th of April. But
Let me take a quick look here, seeing as we have the files right here. So the speedy trial waiver that I can see all 3 cause numbers on has April 17th,
correct.
2025. So
That
even
would-
if we set out to May 8th on a 90-day speedy trial calendar, we're not even 30 days into speedy trial. We needed to go ahead and set matters for trial.
Thank you, Your Honor. I just wanted to be clear on that point.
All right.
Your Honor.
Yes, Mr. Goheen Rango.
Hey, just had a quick question. I've been hearing that term a lot today, speedy trial. And I took 3 years of AP government politics in high school. I'm sort of roughly familiar with some constitutionality about that, but I'm just curious today if you could give me something to think on for the next week till I talk with Brandon. As far as for the position of a defendant, what's the purpose of a speedy trial? And why does it have to be speedy?
I think what was happening, Mr. Goheen Rango, historically was people were languishing in jail with no definitive time frame. And certainly there's been times where speedy trial has been suspended. Most recently, I think when there was an emergency order during COVID, speedy trial was suspended at that time just because we couldn't safely impanel juries. So generally, a person who is in custody has the right to be brought to trial within 60 days. Does not mean that's always the best strategic choice, depending on the complexity of the case. And a person who's out of custody generally has to be brought to trial within 90 days. Certainly, that is a privilege or a right, that a defendant can choose to waive. And a judge like myself, whether it be over Zoom or in person, is going to make a colloquy with that person, making sure that they understand their right to speedy trial, making sure that they understand that from the new commencement date, so in your case, when we last did the speedy trial waiver, that you understood the 90-day time frame for the particular cases would run from April 17th. And ultimately, it's the defendant's choice whether that speedy trial time frame be waived. So that would be my recitation on that.
Okay.
Thank you, sir.
Yeah, thank you. Can you hear me? Oh, sorry, I got muted there for a second. Since my case here in Superior Court.
Please, this
Yeah.
is your attorney currently, Brandon Campbell. I don't recommend you speak
Yeah.
in open court, and if you have questions about speedy trial, we can discuss them when I come into the court or come into the jail between this week and next.
Thank you, Brandon. I'm still just talking with the judge. Thank you.
Just
So
to be
if
clear,
my-
it's against my advice to talk to the judge because he's not.
I
in a role
understand
to
that.
Give you advice.
All right, I'm gonna try to get back on my train of thought here before my turn is over. I have a court matter that I'm currently facing right now here in Superior Court. I don't need to go into detail about it. It is a false allegation, and I've been sitting in jail, languishing for 7 months. Meanwhile, my attorney in that case, which is not Brandon Campbell, Brandon has been awesome. He comes to see me often. He's seen me more times in the short amount of time that he's been my attorney than altogether twice the amount of time than my other attorney who refuses to come and see. It's been 5.5 months since she's been here to see me. And so I'm wondering how I could still be languishing. Yes, it's a different case about a Superior Court matter. But without being able to work on my case here, I know you've released me, which is very gracious, and I always thank you for that. On the older cases, but since these cases preceded my involvement in this newer case 7 months ago, when I was attacked, and then the police they arrested the wrong person and never got my side of the story.
I really recommend you don't speak about this on the record.
Okay.
And I think,
Don't
Mr.
go
Goheen
any-
Rango, where I'm gonna go with this is, it's this
Yeah.
thing that I tell everyone in the courtroom today, and if you were present in the courtroom, one of the things that a judicial officer cannot do is provide legal advice. And I think you're asking me to provide legal advice or to make a ruling on a case that I don't have any information on. Certainly, those are issues very clearly that need to be brought up with your assigned attorney. I can't make a ruling or provide legal advice on a case that is not before the court.
I understand
And
that.
I would additionally also say, like Mr. Campbell is, you are on a record and you are making statements. And if that attorney were here, I'm sure they would ask you not to make any statements that might be against interest. So that concludes your hearing. Thank you, Mr. Goheen Rango. I'll see you next week, sir.
Well, there's the update to the case, and as you see, the attorney does not want to represent him for things that they don't agree on. And I'm wondering in the background if he's talking more the sovereign citizen language than he is. But I did have some people in the comments who was very familiar with him because he's new to me. And in some of his prior hearings, he talked the language. I just haven't seen him. And I think some people were trying to figure out if they can point me in the right direction so I can see how he is in other courts. But as you see, he has a lot of matters going on. So I had to figure out what's going on with him in Superior Court. The problem is I don't know how to spell his name properly, so I cannot find him. If anybody know, send it to me because somebody helped me on another case. I wasn't able to spell the name correctly. All right, so you have a good day, evening, or night. When he comes back, I'll be there and we're going to watch him again. All right, see ya.